We'll let them in. Princey, you can begin.
Good evening, everyone. Thank you so much for attending our webinar today. Our speaker today is Mr. Sudhir Verma, and our topic for the webinar today is international law really a weak law, and an analysis from the prism of Russia and Ukraine's conflict. To let you all know a little bit about our speaker today, he is an alumnus of GLC Mumbai and has completed his LLM in international environmental laws. Apart from that, he is also he feels extremely pride in mentioning that he is a student of JNU, from which he has attained his doctoral scholar in the subject of international law and legal studies. Apart from his educational background, he is also an assistant professor at Symbiosis Law School, Noida. And this year, he was a part of national consultation held by Working Group of Human Rights in India and the UN. It's an extreme honor to have you here today, sir. Before we go on with the webinar, there will be a few links that Mr. Sudhir Verma has prescribed for everybody to read, which will be posted in the chat group on this webinar. Thank you so much. And sir, before you go on with before you take over, I would like to address how are we addressing the questions? Like, how do you want the participants to address questions?
I think I'll take up all the questions in the end.
Okay. I request all the participants to switch on their cameras and have an interacting session. Thank you so much, sir. So you can go ahead.
Okay. Thank you so much, Princey. Thank you so much, SPIL and all the stakeholders for having me here. And it is, of course, an ardent task to pick up a webinar on an issue. It is an ardent task to pick up a webinar or a talk on an issue of such great relevance, which actually questions the existence of international law as against international politics. The conflict between Russia and Ukraine, or I should put it like that, Russia's invasion on Ukraine, or Russia's illegal use of force on. Right. Why are we playing with recordings?
Apologies, I think there was some technical error. It stopped.
Okay. So yeah. Immediately, as soon as Russia attacked Ukraine, and to be very honest, I need to throw up some caveats here, is that it is quite difficult to cover all the issues with respect to this particular conflict in the time allocated to me. But still, I would touch upon those areas so that you may research yourselves, all of you. But I would deal with those areas which people are not talking about in detail. All right. Everybody are talking about all those cliche areas of self-defense, use of force in international law, and so on. I will not spend much time discussing Article 2.4 of UN Charter or Article 51 of UN Charter, or even enforcement measures from Article 39 to 43 of UN Charter. I will not waste my time in that, because you can get a lot of stuff. You can hear a lot of stuff from umpteen number of webinars happening globally on Ukraine and Russia. I will do the needful. I'll fill up the gaps when nobody is talking about. I will be talking about sanctions regime, how the sanctions regime interplays in this particular scenario. You all know that Russia has used force, albeit illegally, against Ukraine, or Ukrainian territorial independence and territorial integrity and political independence, that we all know. We also know that heavy sanctions of widest possible scope are enforced on Russia, especially led by United States. We know that. So we will talk about the legality of these sanctions and how these sanctions are or may potentially violate human rights and humanitarian situations in those sanctioned areas and countries, including Russia. So it would be a pro-Russian approach in that particular part of my webinar. As a surprise. Anyway, but that is one question nobody is talking about, and my work as international lawyer is to give you the merits, howsoever ethically correct it is or not. I'll not go into that. Before that, I would like to let you know about certain aspects of the history of this particular scenario, whatever has happened. How all this has come into play. I mean, what exactly happened that you see that one day Putin has to use force against Ukraine. All right. So of course, yes, I'll be dealing about 2008, 2014, and of course 2022 in that particular discourse of not more than 10 minutes, because it's a lecture not of world history but of international law. And another aspect which I would like to touch upon will be on non-intervention, the legality of intervention and the duty of non-intervention in international law. And the last aspect, if possible, I'll cover up on the aspect of secession, especially with respect to those Donbass territories. What are the legalities attached to secessionist territories in international law? And since I'm talking only about international law is not a weak law, ladies and gentlemen. My first submission of this particular webinar starts with a basic understanding that international law is not a weak law. I'll just spend 2 minutes explaining that particular aspect. Whoever calls for international, I mean, Hans Morgenthau in his book, Politics Amongst Nations, he's always taken the instance that there's no international law, there's only international politics and the politics of mightier nations. Thucydides in his book, History of Peloponnesian War, has 100 times mentioned and has been, sorry, he's mentioned it one time, but 100 times after him, it has been mentioned by a lot of scholars of political realism that the mightier nation does what it wants. The weaker nation must suffer what it should. That's exactly what we are seeing here. All right. That particular text was written centuries ago. Thucydides, History of Peloponnesian War. Later elaborated by Machiavelli in his book, The Prince, and also by Hobbes in the Leviathan. This is part of orthodox realism, which understands that nation states tend to pursue their national interest. And for pursuance of their national interest, the mightier nations take the front seat. And weaker nation can take the front seat. They would never take the front seat, of course. But if they can, if they ally with the stronger nation, that's exactly what Belarus has done in this particular case. We all know. Anyway, so this part of political ideology is today led by a famous professor from Chicago University, John H. Mearsheimer. And he says that he is of an understanding that nation states tend to pursue its national interest, and national interest draw from the citizens of that particular nations, what the citizens want. All right. So can we say that what Putin has done is partly warranted by its own citizens? The answer is partly no, partly yes. Okay, there is a section in Russia. They are against this particular use of force against Ukraine. However, the people for whom Putin has actually waged war against, allegedly waged a war against Ukraine, are for the people of Donbass, or are for the people who are Russian speaking in Ukraine, or the people who are from Russian ethnicity living in Ukraine. He has alleged that since last 8 years, Ukraine has constantly been violating the genocide convention with respect to these people. There is an ongoing genocide according to Putin. Ongoing genocide in Ukraine according to Putin upon those who are Russian speaking or are of Russian ethnicity. So he has taken the plea that it is here that I am punishing and preventing this genocide through the use of force. That's ironical. Anyway, we talk talk about the recent judgment that is delivered by International Court of Justice. That's not the judgment, actually, that's the provisional measures that has been adopted by ICJ. It's a sort of injunction which asks Russia not to do what it's doing. Anyway, but before that, let me come to the basic and ground zero, that international law is not the weak law. I'm here to defend it, my profession. Anyway, so international law, there is a range of scholarship which says that international law is a weak law because there's no world government, there's no world court to enforce international law. But there is a strong opposition to such kind of understanding of international law, is that such idea is based on a misconception or misreading about the nature and basic scope of international law. International law is not the same system as that of municipal law, and the critiques of international law often brand international law as weaker based on their understanding from the prism of municipal law. And weighing down international law from municipal law angle is wrong, conceptually wrong, because I'll just give few differences between international law and municipal law, and you all would agree with me. When I say international law, the subjects of international law and the makers of international law are the same. They are the states. In municipal law, the makers of international law and the subjects of international law are different. All right. So they are not structurally, functionally, conceptually same subjects. All right. You can name it with whatever name, whatever nomenclature you would want to take. Take it as international ethic or morality or international force, whatever. Just branding it as law does not warrant it to be justified from a municipal law perspective. Also, the implementation regime in international law is different. The sovereign is different in international law. The sovereign in a municipal law is the head of the state. I mean, in a realist perspective. It is the head of the, you would all argue that these are the grand norms or maybe constitution, whatever. You may have whatever perspective you want to have. But the basic is that who enforces municipal law? It's via the government. In India, if we apply 74 and 75 articles of Indian Constitution, it is the Council of Ministers headed by the Prime Minister, which is responsible for the governance of the country. That means that this is actually the sovereign. All right. But in international law, the sovereign is the consent of the states. And the consent and a universal consent of the state is reflective in UN General Assembly resolution because of its inherently universal character. UN General Assembly is a purely international body composed of all the member states recognized by UN Charter. However, there's another international organ called UN Security Council, essentially tasked with maintaining international peace and security in the world, is not truly representative global organ, international organ. It is composed only of 15 members, with 5 permanent members and 10 non-permanent members appointed on the rotational basis. So when we say that UN security, the hands are tied of UN Security Council in such a situation when Russia itself is involved in this crisis and itself being a P5, one of the P5 nation, international laws become weak. Sorry to say no, there are other measures as well. Today, I'm here in next one or 1.5 hours, whatsoever it is, I will try to defend this particular aspect. Even if Russia is involved and it vetoes the resolution of Security Council, international law is not hand-tied. It really has the other options as well, and those are being looked into. All right. Apart from diplomatic measures, etc., being undertaken, that is different story. And there is another strong statement given by Alina Kasprovich in her book that often the violations of international law are less than the violations of municipal law. It's often seen that the violations of municipal law are more advertised and they get more global attention than that of violations of municipal law. I mean, if I've by mistaken, if I've talked about international municipal law violations, no, I was talking about international law violation being highlighted by media more than municipal law. Anyway, so these are some of the aspects which defend the strength of international law. Let's not get into those areas much because nobody would be interested in the theories and perspectives around the nature and scope of international law. I'm sure you're not here for that. You're here for understanding the conflict of Russia and Ukraine and the international law question involved in this particular scenario. One must understand the politics. So I'm now getting into the niche area of Ukraine and Russia, going into a bit of background of Russia and Ukraine. One must understand three things. One, that Russia is very sensitive with respect to spheres of influence in its western borders. Russia's international politics revolves around spheres of influence, especially after the collapse of Soviet Union. Russia wants to have certain buffer nations away from NATO, all right, away from Europe. It doesn't want Europe right next to its border. One essential reason behind that is that Russia's western front geographically are grassland. All right. If you come very close to Ukraine, Russia is vulnerable and Russia knows it very well. All right. Let me be very clear here that Russia is being troubled by NATO since 2008. In 2008, NATO declared that it would want Georgia, it has officially invited Georgia and Ukraine as new members of NATO. All right. The trouble started even back when Baltic states became part of NATO, but Russia ignored it. But once Georgia was recognized as a NATO member, Russia immediately condemned that particular incident, saying that this is a grave threat to my national security. And when Russia says that, it is bloody serious. One must understand. All right, Russia and US, if they would say that it is something is threat to their national security, they're very serious. One must understand it from the United States angle. United States do not allow any foreigner entering in Western Hemisphere. And you are entering right next door in Russia, near Russia. You just understand that. You cannot discount the power of Russia as against United States. Everybody knows somewhere that it is potentially one of the superpowers in the world. And you cannot mess around with the national security and strategic interests of Russia. It is always in the favor of Russia. It is always in the favor of Russia to have a pro-Russia Ukraine or a pro-Russia government in Ukraine. All right. So it would do anything to secure that interest. They are very clear about it. And you know it very well that recently there were warnings of tactical nuclear weapons being on alert at Belarusian border against Ukraine. Those threats are real. They must not be discounted for. Those threats are real, even if it is a threat to global peace and security. Understand from Russia's perspective. All right. And understand also from Ukrainian perspective. I've given you Russia's perspective that only thing what Russia wants is a pro-Russian Ukraine regime. That's a Ukrainian regime. That's it. Nothing else. So that rights of Russians in Ukraine get secured. Ukraine can be a credible partner as against the rest of the West. All right. All that Russia is in the favor of Russia and Russia wants it anyhow. All right. Anyway, that if you think I am indicating regarding this particular invasion having a potential target of regime change in Ukraine, in Kyiv, then yeah, I am indicating towards that, but I am no one to predict that. All right. Russia has a history of being involved in regime changes in more than 21 nations. All right. In the post-World War II order. So you cannot discount that possibility as well. All right. Saying that right now would be far-fetched, but yes, you cannot discount that possibility. Second aspect which one must understand is with respect to Donbass region and Crimea in Ukraine. All right, if I use that word in Ukraine, I mean, that's the real terminology I must use. But then anyway, Crimea, Luhansk, and Donetsk. Luhansk and Donetsk are part of Donbass region of Ukraine, and Crimea is very near to this particular region. It's in the south, and Donbass is in the eastern side of Ukraine towards Russia. All right. One must also understand that these are relatively richer areas in Ukraine. A lot of natural resources, a lot of strategic significance, especially with the opening up of sea routes for Russia and all that. So it has geostrategic, geopolitical, and geo-economic significance. In fact, I don't know, do I have that authority to coin a new word, but yes, it has geo-ethnic significance as well. Why geo-ethnic significance? Because major population of these three regions are Russians or Russian speaking, Russian ethnicity or Russian speaking. If I take the average, there are more than 90% people. This is second thing which you should understand in this particular conflict, and why Russia is too much worried about Crimea and Donbass. All right. What Russia wants under Minsk agreement, I'll tell you later. But then please understand Ukraine as well. Ukraine, in general, is a highly divided country. Civil war started in eastern Ukraine in 2022. All right. In February 2014. I'm sorry. In February 2014, civil war started in eastern Ukraine, which led to Putin accusing Ukrainian regime of genocide against Russian ethnic people or Russian speaking people in eastern Ukraine. All right. One must also understand the political divide in Ukraine. The western side of Ukraine is pro-NATO, pro-EU, and pro-US. It means they're supporters of democracy. All right. And the eastern Ukraine is pro-Russia and strictly anti-NATO and anti-EU. May not be anti-US, but it is strictly anti-EU and anti-NATO and pro-Russia. And there is a fracture. I mean, the presidential elections that has happened till now, till now, since 2004 or 6, I think, yeah, since 2004, no regime change is smooth in Ukraine till now. All right, and there's a sort of a shift. One regime is pro NATO, one is pro Russia, pro NATO, pro Russia. Current president of Ukraine, Volodymyr Zelensky, he is pro NATO. Okay, he's supposedly pro NATO, but a softer pro NATO. Okay, anyway, so this is the ethnic background or breakdown of Ukraine. I do have a map, but it will take a lot of time if I show you all the maps. Okay, rather than that, I can ask you to see them later. I'll forward them. I will ask SPIL to forward. I'm sure SPIL have already forwarded you all those readings and links, which I want you to see and read. Anyway, after this particular webinar gets over. Anyway, so actually, I found the exact word in my notes. In 2008, when Georgia became part of NATO, Russia called it an existential crisis for Russia. Russian president called it an existential crisis for Russia. And since then, Russia has been hell-bent towards having a pro-Russian regime in Ukraine. Russia has no intention to annex Ukraine. That is very, very clear. All right, that is very, very clear. Anyway, so I would just say that whenever, so Ukrainian president has always been in a very sensitive situation. All right, if he takes a pro-Russian stand, if he is a pro-Russian and he takes pro-Russian stand, range of protests. If he is pro-NATO and takes some pro-NATO stands, range of protests, and often protests turning violent after 2010. All right, first series of protests that actually led to regime change. It was not a regime change, sorry. It was Orange Revolution. It questioned the free and fairness of the elections, which actually it was a fractured mandate. 52% voted for the president and 52% voted against the president. So the person who was elected that time was Yanukovych, and against whom Orange Revolution was started back in 2004. And after this, after widespread protests, again free and fair election happened. And I mean, there was a blame of election rigging on Yanukovych. Anyway, so finally, after this particular nonsense that happened, Supreme Court of Ukraine intervened, and Viktor Yushchenko became the legit ruler. I mean, the legit president of Ukraine. All right. What I'm trying to tell you, the regime change is not always smooth. This person, Yushchenko, was a pro-NATO leader. All right. And in fact, this is called Orange Revolution, the pro-democratic revolution, pro-democracy protests in Ukraine. Anyway, this was not taken in a good light in Belarus and Russia, right? It was often seen as skepticism, Anyway, in 2010, when Yanukovych won, he's pro-Russia, by the way, and when he won the election, he also did a lot of mistakes, actually. He did a lot of mistakes. As soon as he came, he's taken radical pro-Russian policies, especially with respect to extensions of Russia's right at Black Sea via Ukraine. And that actually irritated Ukrainians, and that irritated United States as well. All right. I mean, giving any strategic favor to Russia in sea will actually irritate United States. Cold War chal nahi raha hai, but still United States will be irritated. That's natural, and Obama interfered with Euro-Maiden clashes that happened in Kyiv, Freedom Square, Independence Square. All right, and then again a regime change. Again, in 2014, June 2014, Petro Poroshenko became the next president, and then in May 2019, the current president came into power. All right. This chronology of presidents are not that important. What is important is one must understand that whenever president wants to take one or the other side, it's always a trouble. Now, this particular person called Zelensky, he is also faced with a strong divide. He's in a very, very difficult political situation. If you guys know, if you all know what is Minsk II agreement and what does it want Ukraine or Russia to do, is I'll just make a very simple arrangement on that. I'll not get into the details of Minsk arrangement because we don't have time, actually, but I'll just briefly tell you what is the problem. See, the problem is this. According to Minsk II, which has been agreed between Putin and Ukrainian president, okay, Minsk II is agreed. Minsk is the capital of Belarus. Anyway, I will tell you about the other diplomatic measures being undertaken as well, but this particular diplomatic measure is categorically important. It lets you understand what difficulties Ukrainian president may actually face. All right, and this is it. Russia wants Ukraine to recognize, to pass an order for an independent election in Donetsk and Luhansk. Russia wants that. ठीक है, अभी रशिया ने रिकॉग्नाइज किया, उससे पहले का रियलिटी. ठीक है, so Russia wants कि इन दो region में Ukrainian regime must allow free and fair elections, but Ukrainian president cannot allow that, having known that there is already pro-Russian sentiment. It would make Russia, it would make these region more closer to Russia, and secession would be more easier then. Abhi to it will be annexation, and you can always question the legality of annexation. That time it would be a properly legal secession, which you would not do, which you could not do anything, which you will not be able to do anything about. All right. So this is the first problem. And Ukraine wants Russia to take away all its troops out of the eastern Ukrainian region. All right. Which Russia denies. Russia has created a false sentiment around this particular narrative, a false narrative being floated around by Russia that no, we are not there. We are mediators. Okay, we are not there in eastern Ukraine. We are just mediators between you and your eastern border. Okay, and a higher moral authority and so on. So this is very difficult. Whenever Ukraine asks Russia to do something, Russia in return either gives a false narrative or will say that first you do this election and then we'll see. Okay. So this is the difficulty, and this is the difficulty that, and this is an impasse which no one is able to solve. An example no one is able to solve, I will just mention you so that you may write down in your notes and you can read it later maybe. The diplomatic efforts to solve this Ukraine-Russia crisis. What all are they? One, Normandy format. All right, that was also listed, and that was also mentioned in UN General Assembly resolution, which was just passed on this particular scenario. Normandy format. It is a format where France, Russia, Ukraine, and France, Germany, Ukraine, and Russia sit together and decide for Donbass. All right, and January there was a good news. They came up with a joint statement. Russia and Ukraine came up with a joint statement that we'll try. Although there was an impasse still, but we will try. And that was a big sentiment, because last time such kind of peaceful statement came in 2019. All right. So such kind of statement was a good news, but turn of events were such. The excitement of United States for NATO in Ukraine was such that Russia was compelled. I mean, Russia thought that is, I mean, I'm telling you with the readings which I have done, for Russia, it was now or never. Either you lose it forever or you do it now. There was no other remedy left for Russia. Anyway, second is the effort being undertaken by NATO-Russia Council. Third is the effort being taken by Organization of Security and Cooperation in Europe, OSCE. Fourth is by US-Russia Strategic Stability Talk. US-Russia Strategic Stability Talk. And fifth is Trilateral Contact Group. Trilateral Contact Group is Russia, UK, and US OSCE together negotiating a settlement. I'll tell you the politics of Trilateral Contact Group and Normandy format. In Normandy format, France and Russia, Ukraine trusts France and Russia in general. Okay. But when we talk about OSCE, there are a lot of pro-Russian nations as well. When OSCE as a whole will negotiate with Russia and Ukraine, there's often an apprehension that Russia will not directly speak, but Russia's allies will speak from OSCE. So therefore, there's often Ukraine avoids this particular trilateral contact group. All right. So this is the reason why it avoids. And Russia is always adamant. Talk to me in trilateral contact group. Another thing which Putin is adamant about is you talk. So what is this Donbass region all about? Basically, they are now currently ruled by rebel groups. There are separatist movements. There were separatist movements in the Ukraine, in the eastern side of Ukraine, in the territories of Donbass and Luhansk. No, sorry, Donetsk and Luhansk. All right. In these territories, these rebel groups have actually got the stronghold away from official government position. Now, Ukrainian government is not able to do anything about it. What Ukrainian government has done is it has passed some discriminatory laws in this particular territory, especially for the old age people and about their pension rights and so on. And there's a lot of food security problem as well because of Ukrainian legislations against this region, and it has led to a lot of IDP and refugee crisis as well. And not refugee as such, but internally displaced people ka crisis is there in this region because of certain legislations being passed by Ukrainian parliament. Basically, इसलिए to compel them to come back. Nothing else. If you will be there, you will face the consequences. If you will be in the eastern Ukraine, you'll be pro-Russian, you'll favor the rebels, then definitely you will face the consequence. That's Ukrainian stance on that. And this is what I think Putin calls genocide. All right. This is, I think, a vague or the broader understanding of genocide as from the Russian angle and so on. Anyway. Once you understand that, what Russia wants. So Russia wants Zelensky to talk directly to the heads of rebels in these two territories. That's not possible. He would never agree for that. If he agrees, something will happen like Orange Revolution, or through a nationwide protest may happen in Ukraine, and a lot of lives may be lost. Of course, lives are still getting lost in Ukraine. That is a sad part. But the logic here is a head of the state will not talk to rebels. If he talks to rebel one-on-one, he is recognizing them heads of those territories. So it's a kind of a tacit acceptance of their sovereignty away from Ukraine, which Zelensky will not fall into. All right, do you understand the legality and the problems associated with all these facts? Now, once we are done with all these facts, you all know that in February last week, Russia attacked Ukraine, special military operations to prevent and punish genocide in Russia, in Ukraine. All right, this is the argument which was given by the special representative of Russian Federation in United Nations. ये President Putin का statement है for you. What is this legality of statement all about? Let's read Article 51 of UN Charter here. All right, you want me to share my screen? I can do that as well. People from SPIL, tell me what should I do? Should I share my screen now?
Yes, so you can share your screen. We'll just permit you.
Okay.
I think it's yes, you can share your screen.
Okay. Can you see my screen by any chance?
No, sir, not yet.
There is some technical problem. Leave it. It's all right. What I want you all, you can also open up all these things in your own laptops or computers. What I want you all to open is, let me give you that list. One is that ICJ order, which was passed, provisional measure. Next, I want you all to open up draft articles on state responsibility. I also want you to open up Nicaragua Merits Judgment 1986. I want you all to open up ICJ statute, Genocide Convention 1948, and so on. Anyway, so let me start reading this particular aspect to let you know the legality involved in this particular case. So what happened once Russia decided to use force against Ukraine? It immediately informed Security Council. Why? The answer is here. Article 51 of UN Charter. Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations until the Security Council has taken measures necessary to maintain international peace and security. That's not important. The important part is this. Measure taken by member in the exercise of this right of self-defense shall be immediately reported to Security Council. This is listed in Article 51, and this is one of the main obligation that you have decided to use force. You'll have to inform this or report this to UN Security Council. All right, and then you can of course go on using the force. Legality and all we'll see later. Anyway, so let me deal with this particular judgment in brief. What this judgment talks about. All right, so this judgment, it's not a judgment, it's a provisional measure being taken, kind of injunction not to let the damage happen to an extent where a resolution is not possible anymore. That's what Ukraine has asked the court to do. Anyway, the title of this is Allegation of Genocide under the Convention on the Prevention and Punishment of the Crime of Genocide. Okay. These are provisional measures taken under Article 41 and 48 of ICJ statute and Article 73, 74 and 75 of the rules of the court. Anyway, on 26th February 2022, Ukraine filed a dispute relating to interpretation, application and fulfillment of Genocide Convention. All right. He said that there's a dispute with respect to the same. And according to ICJ, what exactly is the dispute? What do you mean by a dispute officially? A dispute officially means one With respect to the provision of a convention or customary international law, there are varied interpretation between the two parties. This was laid down in Mavromatis Palestinian concessions case of PCIJ 1924. Mavromatis Palestinian concession case, PCIJ 1924. One. Second, when the dispute arises. Second is when you claim positive, when your claim positively is opposed by the other party. Whatever you are claiming is positively opposed. Exactly opposite is the narrative given by the opposite party. Then it is said to be an official dispute under ICJ jurisprudence. And this was laid down in this particular Southwest Africa case, जिसका नाम title is Ethiopia versus South Africa and Liberia versus South Africa, preliminary objections 1962. And the third thing when a dispute arises is where there are opposite interpretations regarding the questions of performance and non-performance of international obligations. So in these three situations, there is a dispute officially what ICJ would recognize, right? I'm not talking about the jurisdiction yet. I'm just talking about the dispute. Anyway, what does Ukraine wants ICJ to do? What does Ukraine act as Ukraine's contention is this, that with respect to the interpretation and application of Genocide Convention, there is a dispute. And what dispute it is all of pehli baat to Ukraine is denying that there is any genocide, that there has been any genocide in the territory of Ukraine by the Ukrainian government. Number one, which Russia says that it is false. Russia says that, yeah, there is a genocide. It doesn't say it in the ICJ. It has said it into the public disclosures before the waging of the war, before the invasion. There has been a lot of an umpteen number of evidences have been filed by Ukraine in ICJ that Russia has time and again made this particular statement that Ukraine is guilty of genocide. All right. And Ukraine says that no, it is not there. So Ukraine, Zelensky has pleaded one thing, that the court, ICJ, must adjudge and declare that no acts of genocide have been committed in Luhansk and Donetsk oblasts, administrative regions of Ukraine. That's the first contention. Second, Russia cannot lawfully take action under Genocide Convention in or against Ukraine aimed at preventing or punishing an alleged genocide on the basis of false claim of genocide in Luhansk and Donetsk. Okay. This is based on this claim is based on Article 1 of Genocide Convention. Why is Russia, now you need to open Genocide Convention, Article 1, everyone, ladies and gentlemen. Unfortunately, I'm not able to share my screen. I don't know what's the problem. If SPIL can do so, if anyone from the SPIL can do so, Genocide Convention, I would need Article 1 to be read by everybody. It's okay, we can read it later. I'm just continuing the narrative. In Article 1 of Genocide Convention, it is clearly listed down that the contracting parties confirm that genocide, whether committed in time of peace or in war, is a crime under international law, which they undertake to prevent and punish. That's the important word. So preventing and punishing an alleged genocide unilaterally using force against Ukraine is bizarre. Do you understand this? Even if there is genocide, punishing and preventing means you need to take up the measures as listed in UN Charter. You're not supposed to unilaterally use force against a nation like that. You are not supposed to wreck that particular nation entirely. That's not the way. All right. And what did the court say with respect to this particular arrangement, with this particular argument, that Article 1 there's an obligation to international community to prevent and punish genocide happening anywhere in the world, but that has to be done in good faith. First of all, the interpretation of genocide must be done in good faith. The actions must be taken in good faith and in accordance with Article 8 and Article 9 of Genocide Convention. All right. So Article 8 reads like that of Genocide Convention. I'm reading it out. That's why I told you that article. It's very important for you to have this Genocide Convention in front of you. Article 8 reads, any contracting party may call upon the competent organs of United Nations to take such action under the Charter of United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any of the other act enumerated in Article 3. Article 3 defines genocide. Leave that aside. Article 8 बोलता है कि you will call upon the competent organs of United Nations to take such actions to prevent and punish genocide. And Article 9, disputes as understood, what I've told you, those three types of disputes between the contracting parties relating to the interpretation, application, and fulfillment of the present convention, including those related to the responsibility of a state for genocide. Thank you so much. The screen is shared, I think now. Article 9, Article 9, dispute between contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those related to the responsibility of a state for genocide or for any other act enumerated in Article 3, shall be submitted to ICJ at the request of any of the parties to the dispute. You will invoke the jurisdiction under Article 36 of ICJ statute in this particular case. So basically, Article 9 refers to Article 36 of ICJ statute and asks you not to use force, but then to use the channels given in the ICJ charter. I mean, in the UN charter, you must use those pacific settlement of dispute mechanisms. You must use those institutional settings available. You must wait for official sanctions to come in, rather than you yourself taking up those particular actions under genocide convention and whatsoever. This is what Ukraine defends. Okay. Anyway, second claim. Third claim, sorry, not second. Third is Russia's recognition of the independence of Luhansk and Donetsk on 22nd of February 2022 is based on false claim of genocide. That particular recognition or the secession of those two territories out of Ukraine should not be recognized. That is based on false claim of genocide. That's what Ukraine pleads in the ICJ. So Ukraine seeks ICJ's jurisdiction under Article 36, para 1 of ICJ statute and Article 9 of Genocide Convention. Now you know what Article 9 is all about. But let me read Article 36(1) for you. The jurisdiction of the court comprises all cases which the parties refer to it and all matters specifically provided for in the Charter of the United Nations and in treaties and conventions in force, including Genocide Convention. That's what I add apart from Article 36(1). So that's where Ukraine has gone to use ICJ. That's the location. That's the institutional location. And Ukraine has asked for following provisional measure, quote unquote, Russia should immediately suspend military operation commenced with the stated purpose and objective of prevention and punishment of a claimed genocide in Luhansk and Donetsk oblasts in Ukraine. Basically, Donbass mein genocide ke bahane, what all aggression is being taken place, you should be done away with. It should immediately be suspended. Let me tell you one thing, there is no clear-cut definition of the term aggression. All right, there is no clear, I'll just give you a brief jurisprudence of the word aggression because I don't have much time. Aggression is one of the crimes. All right, one of the international crimes, but this particular crime of aggression is not within the original purview of or original jurisdiction of International Criminal Court established under Rome Statute of 1999. If you want aggression to be part of jurisdiction of ICJ, you will have to sign and ratify the amending protocol of Rome Statute 1999, which gives jurisdiction to ICC with respect to aggression. That's it. That's all about aggression. Second thing, in UN Charter, in the entire UN Charter, only Article 39 talks about the word aggression. All right, only Article 39 talks about the word aggression, and Article 39 reads like this. Here, everyone. The Security Council shall determine the existence of any threat to the peace, breach of the peace, or acts of aggression, and shall make recommendation or decide what measures shall be taken in accordance with Article 41 and 42 to maintain and restore international peace and security. That's Article 39. That's the only place in entire UN Charter which uses but not defines the word aggression. One UN General Assembly resolution formally defines aggression is UN General Assembly Resolution number 3314. All right, this is for your reference. All right, now what is the difference between aggression and use of force? If the use of force is a legal use of force, under Article 2.4. If that Article 2.4 क्या पढ़ता है वो भी सुन लीजिए आप लोग. Article 2.4 says all members, in order to ensure to all of them the rights and benefits resulting, sorry, that's Article 2.2. I'm so sorry. Article 2.4, all members shall refrain in their international relations from the threat or use of force against territorial integrity and political independence of any state or in any other manner inconsistent with the purposes of United Nations. If an action is being undertaken against the territorial integrity and political independence of one particular state, you have the right to use force against that particular state within, of course, being within the provision and purposes. You should not be inconsistent with the with respect to the purposes of United Nations, and that is to maintain peace and security. If there's a breach, then restore peace and security. That's it. उससे ज़्यादा नहीं. So that is Article 2.4. All right. Article 2.4 में use किया हुआ force is not aggression. But once you violate Article 2.4, you are actually doing aggression. And aggression is an internationally wrongful act. Internationally wrongful act as understood by Draft Articles on State Responsibility 2001. Draft Articles on State Responsibility 2001. That's the next document I would want you to open. SPIL, please do not share it. I will read the relevant provision as and when required. It's okay. Anyway, so this is what it pleads, that Russia should immediately suspend military operations commenced with the stated purpose and objective of the prevention and punishment of the claimed genocide in Luhansk and Donetsk oblasts or in Ukraine. And by the way, Russia did not participate. Russia said, no, I'm not participating in the. So basically, after filing this particular application for provisional measures, they were asked, you all will be called upon in person or virtually, whatever hybrid fashion may, on 7th and 8th of March for oral proceedings. Russia denied that I won't participate in your oral proceedings because this is a funny argument. Let me tell you, what they have used the word is glue. Ukraine is purposefully gluing use of force with genocide. All right, it is purposefully gluing use of force with genocide convention, and this is beyond the scope of ICJ under genocide convention of 1948. कि genocide को रोकने के लिए हम use of force कर रहे हैं, ये हमने कब बोला? You understand? Russia is outrightly denying कि we are using force to save the ethnic minorities in Donetsk or Yevo. And more so over, it is an existential threat to me. That is why I'm using force. And that use of force is in self-defense under Article 51. It's not at all under Article 1 of Genocide Convention 1948. And therefore, the claim of Ukraine is wrong and it is beyond the scope of this particular case. I mean, it is beyond the scope of ICJ jurisdiction. अब इस पे ICJ is tight slapped Russia. Okay. And what ICJ did was it counted on its past jurisprudence. Number one jurisprudence is para 27 of Nicaragua merits. I will read that for you. Don't open it. Paragraph 27 of Nicaragua case. And that reads like that. Just 1 minute. Yeah. When a state named as party to proceeding before the court decide not to appear in the proceeding or not to defend its case, the court usually expresses regret because such a decision obviously has a negative impact on the sound administration of justice. In the present case, I mean, Nicaragua mein aisa hua tha, and the same thing gets applicable here as well. The court regrets even more deeply the decision of the respondent state not to participate in the present phase of the proceedings. Having taken part in the proceedings to argue the court lacked jurisdiction, the United States, in that particular case, and the Russia thereby acknowledged that the court had the power to make a finding on its own jurisdiction to rule upon the merits. It is not possible to argue that the court had jurisdiction only to declare that it lacked jurisdiction. That's right. I mean, it would be very funny. कि court का सिर्फ एक ही jurisdiction है to decide whether it lacked jurisdiction. Such an argument was denied in this particular paragraph 27 of Nicaragua merits judgment Judgment 1986. In the normal course of events, for a party to appear before a court entails acceptance of the possibility of court's finding against that party. Furthermore, the court is bound to emphasize that the non-application of a party in the proceeding at any stage of the case cannot in any circumstance affect the validity of its judgment. So therefore, you come or not, I will pass the order if I will have jurisdiction, and you cannot say that it is not going to affect me. It will be affecting you according to paragraph 27 of Nicaragua Judgment, Merits Judgment 1986. Second judgment which this particular court, ICJ, has referred to is Provisional Measures between United States and Iran in 1979, paragraph number 13. I would like to read that as well for you. And that is, yes, just a minute. That is another interesting take. Yeah, paragraph 13 reads like that. Nothing that the government of Iran was, I'm so sorry. Noting that the government of Iran was not represented at the hearing, and whereas the non-appearance of one of the states concerned cannot by itself constitute an obstacle to the indication of provisional measures. Clear jurisprudence. Just because Russia is not participating in provisional measures oral hearing does not stop the court to deliver this particular provisional measure, and that's why you have it now. That's the logic. That's why you have it, and that's why world is reading it, and we are also reading it. Anyway, now I will come to the main point, that international law is not weak, ladies and gentlemen. In Security Council, there was this resolution 2623 of 2022 on this particular aspect on 27th of February 2022. On 27th of February 2022, that particular resolution was vetoed by United Nations Security Council by Russia. Okay, that particular resolution was vetoed by Russia, but that particular resolution marked up another thing. See, you need to understand the veto power. You cannot veto all resolutions of UN Security Council. Number one, please understand this. You can only veto substantive law questions of UN Security Council. You cannot veto procedural questions of Security Council. So what UN Security Council has done in this particular resolution is it has referred the same to UN General Assembly, and that's a procedural resolution. That's why that resolution got passed with more than 10 votes in favor. You just need 9 votes, P5 or non-P5, it doesn't matter. So now this particular thing is now referred to UN General Assembly, and UN General Assembly, in light of this particular UN Security Council, has passed a resolution on March 2, 2022, and that resolution has said all these things. One, Uniting for Peace resolution was called upon. Uniting for Peace resolution was called upon. Uska number hai 377A5 of 3rd November 1950. 377A5 Roman 5 of 3rd November 1950. That is United for Peace resolution, and which says that if a country applies veto, then UN General Assembly will go on with the purpose of restoring international peace and security via a procedural resolution of UN Security Council. So this is via Uniting for Peace resolution. Now you know, right, that international law is not a weak law. Don't say that again. P5 hoga, veto hoga, doesn't matter. We have United for Peace resolution. We have UN General Assembly. Right, I agree that UN General Assembly has a persuasive, resolutions have a persuasive character. I will tell you about the treaty-based character of sanctions as well, or measures or countermeasures as well, very soon. All right, anyway. Second, UN General Assembly resolution has mentioned another resolution, that is resolution number 2625 of 1970, that is Friendly Relations Declaration, a very famous declaration. And it says and highlights that the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. You cannot take that. Then again, it refers to another recalling resolution number. So the third resolution it recalls is resolution number 3314 of December 1974, that defines what aggression is, and General Assembly resolution lists this particular event as aggression, not use of force. It's aggression. All right. And then it recognizes that there are a lot of IHL, international humanitarian law violations, refugee crisis happening in Ukraine, and IDPs, and a lot of food insecurity as well. Food insecurity, I mean, Ukraine gives grains to a lot of countries. It is responsible for food security of a lot of countries, and global food insecurity is directly dependent upon Ukrainian territorial integrity. One must know. All right. I have talked about those diplomatic efforts. I'll just talk about, I forgot to talk about Minsk agreement a bit. Let me give you some markers there on Minsk. What does Minsk agreement, actually that was recalled in this particular resolution. It was recalled. Three diplomatic efforts are recalled in this particular resolution of UN General Assembly of 3rd March 2022. One is Normandy format must be revived. Second, trilateral contact group must be given favor to. Third, Minsk sentiments must be abided by. And what are Minsk sentiments? Number one, giving special status to Donbass region within Ukraine. Number two, organizing local elections in Donbass region. Third, restoring Ukrainian government's full control of its borders. I mean, Russian troops getting out of Donbass region. Fourth, disarming fighters in separatist held areas. कि separatist areas में आप जो weapons provide कर रहे हैं, वो मत provide करिए आप. Don't do that. Disarm them. All right. Next, or of course, it is very difficult for Ukraine to abide by all that. Anyway, ठीक है. क्योंकि मैंने आपको बताया, Russia wants Ukraine to talk directly to those leaders, and then it says I'll agree with all this. You talk to them and I'll agree with them. You talk to them, hold elections, and I'll agree. That's a catch-22 situation given to Ukraine. No, I mean that doesn't work like that. Anyway, Genocide Convention के बारे में एक बात बता देता हूँ कि this particular convention came up in it was adopted in 1948, and in 1954 both Russia and Ukraine ratified this particular convention. Okay. It talked about those three types of dispute regarding varied interpretation, claim being positively opposed, and the opposite interpretations regarding the performance and non-performance of international obligation. ICJ provisional measure also talks about genocide being happening in Luhansk and Donetsk in Article 2. कि Article 2 के हिसाब से genocide और Luhansk genocide जो Donbass region में that has been argued by Russia is wrong. I mean, it's not going into the legality of that, but yes, it takes up the jurisdiction based on Ukrainian argument that Article 2 का violation जो Article 2 that defines genocide is being violated in Ukraine and being accused of by Russia is one of the reasons why we have come to you under Article 9. So Geneva Genocide Convention in whole and in toto is applicable in this particular case, and court has actually taken up the jurisdiction and given the provisional measures and have asked Russian troops to get out. Okay, that's the summary. Okay, and conclusions draw around from page number 19 to 22. You can read it yourself in this particular listing. I'll pick up the next issue, that is the sanctions regime. All right, I'll quickly touch up the sanctions regime because I think I'm lacking a lot of time. I'm going very in this thing. So anyway, so sanctions are now, after taking a pro-Ukrainian stand, let me also deal with the merits. We have to evaluate the facts on merits so that we don't get too much biased for or the other. And that's where we will be able to respect international law, and only pro-Russian stand which can be taken under international law is with respect to these sanctions being implemented on Russia. Because sanctions are disproportionate, and sanctions have led to a lot of human rights and humanitarian crisis. Okay. And there's a question with respect to unilateral implementation of sanctions against Russia, whether it is legal or not. See, sanctions का मतलब क्या है? Sanctions का मतलब होता है कि it is sort of a legal positivistic notion highlighted by Kelsen. So there's a Hans Kelsen perspective that only institutions, only international organizations are responsible to invoke sanctions. No one else. Only international organizations are responsible to invoke sanctions, and now the sanctions are being taken unilaterally by EU and US. That is illegal. That is what the argument is. And the sanctions are widespread. The scope of sanctions are widespread. All right. And what are those sanctions? If I list out the few, number one, reserves of Russian central bank. In, by the way, what sort of sanctions are these? They are called targeted sanctions. Actually, sanction ki regime bhi historically change hui hai. Earlier there was something called global sanction, or a wholesome sanction. You actually sanction the entire state and its nationals and its corporations and MNCs, etc. All right, now there are targeted sanctions. You're picking and choosing the corporation and persons upon which you want to oppose the sanction. All right, this is actually, I would support this kind of ideology, that this is a better way of invoking sanctions rather than entire state being responsible. You just invoke sanction on the targets. So yeah, the sanctions are, number one, reserves of Russian central bank in foreign countries are frozen. That has costed Russia $300 billion. Number two, Russian and Belarusian bank have been cut off from SWIFT, that is international payment system. Anyway, third, reserves of nationals of Russia and Belarus abroad have been frozen. This is wrong. Un citizens ki kya galti hai? Travel bans, which include civil aviation, which is hurting, which is actually hurting the profits of civil aviation. This is, again, there's no mistake of them. Anyway, the travel bans, again, it should be targeted, not a blanket sanction. Anyway, fifth, sector specific sanctions, including fertilizers. Okay. Fertilizers is hurting global agriculture, and global food commodity index is going to soar high because of less supply. This is going to hurt globally. Anyway, so this is again not a very good idea. Sixth, ban on imports to Russia. US ने ban कर दिया imports Russia में 520 products including cosmetics. Now what have those US traders got to do about this particular crisis? Why are you stopping them from importing into Russia? There's no logic. Anyway, cutting access for Russian and Belarusian media. Why? Everybody has a right to know what is happening in the world. Only then they can make an informed judgment about it. This is wrong. No. Fourth is no more developmental and research aid projects in Russia and all those sanctioned countries. Why? What have researchers and academicians of Russia and Belarus has done in this particular thing? You cannot do that. I mean, again, they are doing it. Okay. And the problem with these sanctions, अब ये unilateral measures, अभी मैं legality of unilateral measures की बात करने वाला हूँ. I'm talking about कि sanctions की legality क्या है, in sanctions की at least. For that you need to understand 2-3 things. One, sanctions का मतलब होता है sanctions coming out of formal institutions or international organizations. All right, these sanctions, when it comes from one or the other nation or group of nation, it is not sanction, it is unilateral measures or unilateral sanction, often used interchangeably. And unilateral sanctions are not allowed in international law. All right, what minimum you can do is countermeasures. All right, and countermeasures can only be done under the draft articles on state responsibility by Ukraine only, no one else. Okay, but Ukraine ke behalf pe international community can also can undertake countermeasures if the act of Russia is a threat to global peace and security, is a threat to global legal order. Yes, it is a threat to global legal order. The countermeasures for Ukraine can be taken by other countries, but in the name of unilateral measures, no, never. Do you understand this? Basically, इसको कहते हैं बहती गंगा में हाथ धोना. So basically, people are, countries like some of the countries in EU and US are using this particular opportunity to stoop Russia even more lower. Okay, I'm using stooping Russia lower, not more lower. What is that? Anyway, so unilateral measures किस तरीके के होते हैं world में आप देखिएगा. Often phraseology ऐसी use करते हैं कि you often get confused what unilateral measure is all about. They would use the words like restrictive measures, preventive measures, secondary measures, primary sanctions, secondary sanctions, targeted sanctions, individual sanctions. Such broad terminology are dangerous, as all of them pretend to be imposed in good faith and not constituting unilateral coercive measures. So जब real में unilateral coercive measures होंगे, not in good faith होंगे, who will define the legality of such measures? So you have to be very clear about the nomenclature of the sanctions being used. And Human Rights Council has already come up with a resolution in this particular case, by the way. which says that these sanctions are affecting the human rights and are causing humanitarian law violations in the sanctioned countries. UN Human Rights Council resolution has already said about that, and 2/3 countries have favored that particular resolution, and 1/3 countries have opposed that resolution, and 1/3 countries are those countries which have taken unilateral measures. You understand? So at least 66% of global community thinks right now that the sanctions are disproportionate and illegal. They're not coming from the correct channel. All right. And they are in disguise of countermeasures under draft articles of state responsibility. Anyway, so basically what they're arguing is that it should be UN General Assembly or UN Security Council resolution that should announce unilateral coercive measures. And in fact, UN Security Council or UN General Assembly के जो resolutions है, there are umpteen number of resolutions in the past which have announced these unilateral coercive measures as illegal in past. So why not the same jurisdiction applicable right now? Big question mark. You understand, when US is involved, all this legality gets hidden. When Russia is involved, when US is involved, all this becomes legal. When Russia is involved, all this become illegal. And when Russia is involved, all these are becoming legal. That is not the problem of international law, but with the interpretation of international law or the creative interpretation of various provisions or the use of various provision in various times in international legal order, international politics and legal order. Anyway, so the short point which I want to make is that the legality of every sanction must be tested under international law. All right. UN Charter में clear दे रखा है. There is a mechanism for enforcement measures under Article 39, 40, 41 and 42. मैं उनके title ही पढ़ लेता हूँ. I'm not reading the entire article. ठीक है. Even अगर मैं title भी पढ़ता हूँ तो 39 से 43 जो है Chapter 7 का part है, and Chapter 7 का जो heading goes like this: actions with respect to threat to the peace, breaches of the peace, and acts of aggression. Article 39, 40, 41, 42, and 43. They are enforcement measures collectively taken by United Nations Security Council to restore international peace and security. When such measures are there, why are you going for unilateral sanctions? One argument given is that Russia will use the veto. Then you have General Assembly. Then you have countermeasures under state responsibility. Why are you not using these two channels? Because you want to use this opportunity against Russia, to invoke sanctions against Russia. Okay. Anyway, so you must understand the merits of both the arguments. Anyway, so countermeasures under draft articles of state responsibility are listed. I'm just discussing the legality of countermeasures in international law. In international law, countermeasures ki legality are listed in Part 3, Chapter 2 of Draft Articles of State Responsibility 2001. And these are some of the summaries with respect to the countermeasures as highlighted in draft articles. Number 1, countermeasure can only be taken against a state responsible for an internationally wrongful act. So Russia is a responsible state for this particular purpose. Number 2, it shall not affect the obligation to refrain from the threat or use of force obligation for the protection of fundamental human rights, obligation of humanitarian character prohibiting reprisals, obligations under peremptory norms of general international law. मतलब आप लोगों को इन चीजों को respect करना, these principles cannot take the back seat while you are undertaking countermeasures. What all are they? Number 1 is that the obligation to refrain from the threat or use of force will always be there. Number 1, countermeasure may be आप use of force की doctrine को violate नहीं कर सकते. It has to be a legal use of force. Number 2, obligation of humanitarian character prohibiting reprisals. Reprisals or badle ki bhavna in international law is illegal. All right, reprisals is not allowed in international law. Obligations under peremptory norms of general international law. Peremptory norms are defined by Article 53 of VCLT, Vienna Convention on Law of the Treaties, which says that these are those norms of international law from which no derogation is permitted, even in case of emergency. Like, for example, torture. Like, for example, genocide. You cannot be doing it. You cannot be violating certain humanitarian law principles. All right. Anyway, again, recourse to peaceful settlement of dispute will not be cut off because of countermeasures, and respecting the inviolability of diplomatic and consular agents. Matlab, consular immunity will not be forfeited because you are taking countermeasure. No. Second principle, as highlighted in state responsibility articles, that the countermeasures must be proportionate. The responsible state must be in loop so that the scope of negotiation doesn't end. Even while taking countermeasures, you are not the enemy as such. You don't have to behave like enemy. You have to always you have to always maintain those conditions where even for 1%, if there is chance of peaceful reconciliation, even during that conflict, that should not go away. All right. And very important, Ukraine की legality. आपको पता है, Ukraine has defended its territory very well in this particular crisis. This is legal defense. Self defense तो है ही, but state responsibility का भी एक part है. State responsibility में there's an essentially one important article stating that is that कि urgent countermeasures can be taken by the victim state. It is part of its state responsibility. Okay, to defend its sovereignty. Anyway, countermeasures must be suspended if the dispute is pending before a court or tribunal. Matlab, Ukraine can no more use force now, once it has opened up the channel of ICJ. In fact, Russia must immediately stop all sorts of hostilities. Article 48 of state, I would ask SPIL to please open up Article 48 and 54 of draft articles of state responsibility. I will read that, but let me give you the summary. So Article 48 talks about the invocation of responsibility of the state other than an injured state. That's what is a legal way of recourse of third parties. That must happen under Article 48 of draft articles of state responsibility, and not supposed to take unilateral measures. You have to take those actions under Article 48. So hai ki nahi international law strong? So Security Council, fine. If you don't have Security Council, you cannot go to Security Council, fine. All right, agreed. You can go to General Assembly. Then you would argue that General Assembly is purely recommendatory in nature, etc. It doesn't have the force. It is soft. It is not hard. Okay, then come to Article 48 of state responsibility, draft articles. Now, this is something which you must take care of. And one more thing. Article 48 is also part of erga omnes norms. Article 48 is also part of erga omnes norms. Erga omnes का मतलब ये होता है कि the violation is such that it is a threat to the entire international community. Then the third parties can take countermeasures on behalf of the victim party. Do you understand that? Not in every violation of international law, the third party will take countermeasures under Article 48. It will only take when there is a violation of erga omnes norms. It is against the entire international community at large. Only then. So erga omnes is what? Erga omnes ka matlab it concerns all state. Measures can be unilateral, as the action may be considered not just against one state, but against the entire international community. Such kind of measures are legal measures, and this is also part of Grotian philosophy. Grotius is the father of, Hugo Grotius is the father of international law. उनकी जो बुक थी डी जूरे बेली एक पेसिस, उसकी बुक 2 चैप्टर 20 पैरा 40 में इस चीज का रेफरेंस है. ऑलराइट, कि इसका लॉजिक क्या है? स्टेट रिस्पॉन्सिबिलिटी, थर्ड पार्टीज डिफेंडिंग का लॉजिक क्या है? लॉजिक सिर्फ ये है कि इट इज अ वायलेशन ऑफ एर्गा ओमनिस रेगुलेशन नॉर्म्स व्हिच इज एक्चुअली कंसीडर्ड एज अ वायलेशन अगेंस्ट इंटरनेशनल कम्युनिटी. मतलब ये है कि रशिया ने जो यूक्रेन के साथ किया वो यूक्रेन के साथ नहीं किया है. इट हैज थ्रेटन्ड द एग्जिस्टिंग इंटरनेशनल लीगल ऑर्डर. इट हैज थ्रेटन्ड द इंटरनेशनल पीस एंड सिक्योरिटी. इट हैज थ्रेटन्ड द इंटरनेशनल स्टेबिलिटी. It is therefore an action not against Ukraine, but against the world at large. Do you understand that? This is the narrative for Article 48, very clearly. So you need to prove that Russia has grossly violated. So basically, what you need to do is whenever the case will happen, so you need to prove that Russia has grossly violated fundamental principles of international law, which have the potential to shake the existence of entire legal order of the world, a threat to international peace and security. Therefore, any measure taken by the international community or EU or US are lawful measures under Article 54, read with Article 48 of Draft Articles of State Responsibility. I think the screen is not getting Article 54 for you, ladies and gentlemen. State responsibility. Article 48. Invocation of responsibility by a state other than an injured state. Any state other than an injured state is entitled to invoke the responsibility of another state in accordance with paragraph 2 if, number 1, the obligation breached is owed to a group of states including that state and is established for the protection of a... No, this is commentary. No, this is commentary. This is ILC commentary on state response. Leave it. I'm reading it. It's all right. No problem. No problem. I'm reading it. Please pay attention to what I say right now. Any state other than an injured state is entitled to invoke the responsibility of another state in accordance with paragraph 2 if, number 1, the obligation breached is owed to a group of states, including that state, and is established for the protection of collective interest of the group. Number 2, the obligation breached is owed to the international community as a whole. This is erga omnes. Number 2 paragraph says that any state entitled to invoke responsibility under paragraph 1 may claim from the responsible state. Matlab, the entire international community can claim from Russia what? Number 1, secession of the internationally wrongful act and assurances and guarantees of non-repetition. Number 2, performance of the obligation of reparation in accordance with the preceding articles. Reparation ka right bhi diya hua state responsibility in the interest of the injured state or the beneficiaries of the obligation breached. And Article 54 reads like that, titled as measures taken by state other than an injured state. This chapter does not prejudice the right of any state entitled under Article 48 paragraph 1 to invoke the responsibility of another state to take lawful measures against the state to ensure cessation of the breach and reparations in the interest of the injured state or of the beneficiary of the obligation breached. So basically what I was talking is all about Article 48 and 54, that any state can take the actions against Russia, provided if you prove that the measures taken by Russia has shaken the conscience of entire international legal order. Anyway, there is lot more I want to speak in this particular thing called the sanctions, but it will take a lot of time. I'll just summarize. Okay, I'll just summarize. Dear SPIL, I'm actually mindful of the time as well. I can see the losing interest as well in the audience, but yeah, I'll just complete in next 10-15 minutes. All right. So summary with respect to sanctions are these, that unilateral sanctions as countermeasures can be taken, but you must be careful of the following. Number 1, not all measures necessary to be taken into account in countermeasure are taken care. Okay. So this is the first thing. कि क्या होता है generally what I'm trying to tell you, in the name of countermeasures, you are not supposed to violate the doctrine of proportionality. You're not supposed to undertake disproportionate sanctions or countermeasures against responsible state. Okay. Necessity must be established. Second principle is that necessity of taking those countermeasures must be established. All right. And the purpose should only be to stop the violation of international law by the responsible state. And there must not be any violation of fundamental human right that is happening in these sanctions right now against Russia. There are fundamental human right violation. Human Rights Council resolution says so. All right, rights. There are a lot of IHL violations going on. There are a lot of refugee crisis that is happening. You know it. 420,000 refugees have gone out of Ukraine already. Anyway, this is all about sanctions. This is not all about sanctions. This is part of what I wanted to talk about sanctions. And now the last thing is non-intervention, the doctrine of non-intervention. Let's discuss intervention from the prism of Ukraine and Russia. All right. I think the attention span would degrade if I move forward. What we can do is we can take a 3 minutes break and continue again. It's my suggestion to spill.
Okay, sir, we can do that, whatever suitable for you.
3 minutes break. We meet at 38, 7:38.
Okay.
Yes. All right. I'll quickly touch up intervention and secession. Bear with me. I'm sure. Do not worry about the writing of the notes. What minimum I can do is I can forward that up to spill. All right, my notes which I have made. You all stay after the webinar, what I'll do is I'll scan the notes, put it on the chats for you all. You can take it. All right. No need to write, just concentrate what I say now. Anyway, non-intervention. All right. So intervention जो है दो तरीके का होता है. Intervention एक होता है via consent of inviting state. ठीक है. It can also be in. So there's a international law question here. Can the rebels invite intervention? So this particular question is specially relevant for Donbass region. Can the rebel leaders invite Russia's intervention in Ukraine is a big question mark which we will deal with. All right, one. And second is legitimacy of inviting state. All right. So इस पे दो चीजें आती हैं. One is effective control test according to Nicaragua paragraph 99. Paragraph 9 Nicaragua case paragraph 99. And second is another there's a Tadic case that laid down a test called overall control test. So basically overall control test and effective control test के बारे में मैं आपको बता देता हूँ. So let me read paragraph 99 of Nicaragua case. I just need to pay attention थोड़ा बहुत बस. That's it. Just a minute. Yeah, paragraph 99 reads like this. So basically, it is one of the ground of inadmissibility which was portrayed by United States as against Nicaragua, and it reads like this. The fourth ground of inadmissibility put forward by United States is that the application should be held inadmissible in consideration of the inability of the judicial function to deal with situations involving ongoing conflict. मतलब ये कि if the central government is not having effective control over its territory, then that particular government cannot call for intervention. This is effective control test. All right. So please understand. And in effective control, it is key. In overall control, Tadic case, the case goes like this. In the overall control test, it can include the rebel territory also. So technically, in overall control test, Ukraine cannot accept intervention from Russia. But the rebel group can invite intervention, and there are precedents there. And that is where law of secession comes in favor of Donbass region. All right, you must understand this. But before doing all that, before leading you into that complicated narrative between effective control test and overall control test, I want to tell you another thing with respect to what is the legality of non-intervention. Non-intervention is a treaty law as well as a customary international law within the international legal regime. Okay. It was I will not be I think I should read that. In Nicaragua versus United States, paragraph 73, it was said that the principle of non-intervention in someone else's territory is a customary international law obligation. Customary international law obligation is a universal obligation which doesn't require you to sign a treaty. All right. Customary international law comprises of two components. One is a global state practice, and second, an acceptability of law of that particular global state practice. If that is proved, then that particular principle becomes a customary international law principle, and non-intervention is customary international principle as mentioned in Article 38, Clause 2 of ICJ statute. That is a source of international law, and paragraph 73 of Nicaragua case reads like that. Let me read it for you for a moment. It may first be noted that the multilateral treaty reservation could not bar Yes, this is the same paragraph. Yes, it may first be noted that the multilateral treaty reservation could not bar adjudication by the court of all Nicaragua claims, because Nicaragua in its application does not confine those claims only to violations of 4 multilateral conventions referred above. On the contrary, Nicaragua invokes a number of principles of customary and general international law that, according to the application, have been violated by United States. The court cannot dismiss the claims of Nicaragua under the principles of customary and general international law simply because such principles have been enshrined in the text of the convention. अब इससे एक principle आता है. Actually, it lays down principles such as those of non-use of force, non-intervention, respect for independence and territorial integrity of states, the freedom of navigation continue to be binding as part of customary international law, despite the operation of provision of conventional law in which they have been incorporated. So what it wants to tell you is that customary use of force, legality of the use of force, non-intervention, all this is customary international law, even if it is listed in a convention. Just because a customary international law is written down in a treaty doesn't mean that it stops to be a customary international law. See, there's a significance with respect to that. Customary international, that's where international law is different to municipal law again. Customary international law has universal application. You sign a treaty or not sign a treaty, if it is a customary international law, it is applicable onto you. Only thing is that you are supposed to be a state recognized under UN Charter. That's it. Number one. Number two, treaty. Treaty is only applicable to those who are signatories, who have ratified that particular treaty. It would depend upon you are a monist system in international law or a dualist system in international law. I'll just briefly tell you about that as well. Monist system is that which treats international law and municipal law as one system. That is given by Kelsen. That according to that system, any law made in international law becomes automatically applicable in municipal law. So direct application test is there. All right. So there's a direct application of an international law in municipal law. It creates the rights and obligation at the grassroots. You and me. If India is a monist country, it's not. If India is a monist country, then any international law signed there by India is automatically applicable in India. All right. But dualist doctrine, as elaborated by Harsh Lauterpacht, is that in dualist regime, you have to ratify that particular convention. That means that after signing, you'll have to pass a law, a municipal law based on that treaty. Our entire domestic IPR regime is an example of Berne and Paris Convention being ratified by the Indian jurisprudence. SPIL is quite active in IPR jurisprudence, so that's why I gave the IPR example. Anyway. So that's the difference between a treaty law and a customary international law, and non-intervention is a customary international law according to para 73 of Nicaragua case 1984. So evidence of direct and critical combat support to the contra force need to be established. Okay, for non-intervention, evidence of direct and critical combat support. See, I'll tell you, intervention सिर्फ ऐसे नहीं होता है कि Russia has shot the missiles into Ukraine is intervention. No. Supplying of arms to those contrabands, to those rebels, separatists is also part of intervention. So you understand that Russia is in violation of this essential customary international law principle of non-intervention. Do you understand that? So after that, I'll just read one particular line. Evidence of direct and critical combat support to the contra force need to be established, and if established, it would tantamount to direct intervention by Russia, and that all contra operations reflected strategy and the tactics wholly devised by Russia will be part of intervention violation of Russia. And this was also highlighted in paragraph 108 of Nicaragua merits judgment. This particular aspect which I was talking about, that aapko armed bands ko weapon supply kar de rahe ho, this is also part of intervention, and the violation of customary international law principle is highlighted in para 8 of Nicaragua judgment, merits judgment. All right, I'll just read briefly that merits judgment for you all. Paragraph 109. What the court has to determine at this point is whether or not the relationship of the contras to the United States government was so much one of dependence on the one side and control on the other, that it would be right to equate the Contras for legal purposes with an organ of United States government or acting on behalf of that government. So same applicability we can impose here, that these Contras acting in Donbass region are actually working for Russia. And this direct application test would later on transform into a doctrine that it is not the Contras, it is actually Russia intervening directly, even if it is via Contra. Do you understand that? That is non-intervention principle applicable here. And the last part of this particular webinar which I've chosen is the aspect of secession. Now, do you understand why have I not taken use of force and self-defense like cliche areas? That you can get anywhere. These areas nobody is talking about. So secession. So we'll just talk about secession as an international, the international law of secession, especially with respect to these two rebel territories of Donetsk and Luhansk. All right. So secession in international law is neither legal nor illegal. One, it's neither legal nor illegal. Secession ko leke sabse ambiguous hai international law. This is where international law is weaker also. All right, I agree with that. I didn't want to end with that, but that's how it is. Anyway, so international law is neither, it is neither legal nor illegal, secession. Okay. Secession is based on two aspects. One is on legitimacy and other is on legality. First, I will be in first 2-3 minutes, I'll cover legitimacy, and the next 2-3 minutes, I'll cover legality aspect. So legitimacy aspect क्या होता है कि आप secession कब कर सकते हैं? जब आपकी टेरिटरी में ऑपरेशन हो रहा हो, मतलब फंडामेंटल ह्यूमन राइट वायलेशन हो रहा हो, जेनोसाइड हो रहा हो. सो रशिया ने जेनोसाइड का आर्गुमेंट क्यों दिया? आप समझ रहे हैं? ताकि later it can create those grounds for recognition of those two territories which have actually done so. So please understand the chain of events. First, Russia accuses and keeps on accusing Ukraine of genocide in eastern Ukraine. And then it recognizes those two territories based on the idea of legitimacy there, so that it gets seceded out of Ukraine. Second is geographical, कोई geographical difficulty है या ethnicity related है या violation of human right है by the central government या फिर referendums हुए हों आपकी territory में, सब कुछ हुआ है यहाँ पे डॉनबास में. आप समझिएगा इस बात को, ठीक है. और एक और important aspect है कि आपके nation state की stability hurt हो रही है. Stability जब hurt होती है, it hurts your ability of international cooperation. That also has a tendency to destabilize international order. So that's where secession may be allowed. But there is a twist to this, which was listed in frontier dispute case, which is called Burkina Faso versus Republic of Mali case of 1986, paragraph number 25. The jurisprudence established in frontier dispute case between Burkina Faso and Republic of Mali in paragraph 20 and 25 is that it's a thing between self-determination and the right to secession. So one is you have right to self-determination, and the other is that you have right to secession. Do you have a right to secession, which is an ambiguous right? So in this particular case, it said that both these particular things must be balanced. इसने एक बात बोली अफ्रीकन यूनियन के हिसाब से, आपने देखा होगा अफ्रीकन यूनियन मैंडेट्स था और वो चौकोर बटा हुआ है. इट इज आर्टिफिशियली अलाइंड. जैसे इट्स अ मैप, the makers must have artificially drawn lines and now these are the countries. So you'll find them in a rectangular or square fashion. वो naturally नहीं हुआ है, accidentally हुआ है. sorry, naturally नहीं हुआ है, artificially हुआ है. ऐसा किया गया था, ठीक है. Nobody took care of ethnicity and ethnic mix-up within those nations. That's why you see a lot of, like for example, Rwanda between Tutsis and Hutus, that famous genocide. ठीक है. ये सब क्यों हुआ? क्योंकि ऐसी दो एथनिसिटी को एक नेशन में जोड़ दिया जो साथ में रह ही नहीं सकते थे, ठीक है. बट दिस पर्टिकुलर केस क्रिएट्स अनदर नैरेटिव कि इंडिपेंडेंस स्ट्रगल्स जब हुए थे, व्हेन दोस इंडिपेंडेंस स्ट्रगल्स वर हैपनिंग, a lot of nations, a lot of ethnic groups, even if they are opposite ethnic groups staying within the same territory, they all have worked together for that independence. So it has the long tradition of unity. So self-determination must not be violating the frontiers of frontiers or the borders being laid down during independence struggle. So that's the balance which paragraph 25 wants to make. So this is the argument against the right to self-determination of the people of Donbass. And that is a strong argument in favor of Minsk I agreement, that rather than giving them independence, give them autonomous status within the Ukrainian territory. That would be a nice balance of respecting the international jurisprudence on this matter, right to secession and right to self-determination as well. It would be a nice balance. So let me read this paragraph 25 for you all, once and for all. Yeah. However, it may be wondered how the time-hallowed principle has been able to withstand the new approaches of international law as expressed in Africa, where the successive attainment of independence and the emergence of new state have been accompanied by a certain question of traditional international law on right to self-determination. At first sight, this principle conflicts outright with one another. The rights of people of self-determination, right to self-determination, and your independence struggle, ye aapas mein they don't go together. All right, this is what this particular paragraph balances. In fact, however, the maintenance of territorial status quo in Africa is often seen as the wisest course to preserve what has been achieved by the people who have struggled for their independence all together, and to avoid a disruption which would deprive the continent of the gains achieved by much sacrifice. The trade-off between the sacrifice for independence and the right to self-determination falls on the former. That is what it says. The essential requirement of stability in order to survive, to develop, and gradually to consolidate their independence in all fields has induced African states judiciously to consent to the respective of colonial frontiers as laid down by their colonial masters, and to take account of it in the interpretation of the principles of self-determination of the people. You have, so basically the short point is that you have the right to self-determination, but you need to respect the territorial frontiers as laid down by your colonial masters, because you have fought for that independence altogether, irrespective of opposite ethnicity within one particular border. You understand कि colonial, देखो अभी हमारा colonial struggle था, extremists थे, हिंदू revolutionaries थे, खिलाफत movement था, but क्या हम सब अलग हो जाए क्या? नहीं, we have all fought together, and we have to stay together in the territorial integrity and political independence of this nation. I mean, just because you belong to different religion, ethnicity, caste, creed, and race, that can never be the answer. Why? There's another argument being given in this. I must have written somewhere, but there's another argument being given. It is given by Marty Koskenemi, a professor. Okay, and he said that, okay, fine, if we allow secession in these respect, then आप क्या guarantee है कि डोनबास अलग होने के बाद भी ethnic clash नहीं होगा? क्या guarantee है? ऐसे तो अगर आपने एक स्टेट में सेसेशन अलाउ कर दिया तो दुनिया में सारे स्टेट टूट जाएंगे, इंडिया टूट जाएगा. Do you understand? The entire stability of world order will vanish. You cannot allow that to happen. You need to reconcile these ethnic interests. That's the legality of secession. And a lot more I wanted to speak, but I'm now too tired. Thank you so much. Thank you so much, SPIL, and have a nice day, all of you. But I'm here for questions, if any. I'm scanning it for you all to be pasted in the chats. I'm just scanning it for you all. Short point. What all are other areas where international law is being looked into in this particular conflict for your knowledge? One is with respect to international criminal law, Article 12 of Rome Statute. Okay, with respect to war crimes, crime against humanity, and genocide. All right. There, आपको एक बात जान के आप सभी लोगों को एक बात जान के बहुत खुशी होनी चाहिए कि यूक्रेन has invoked more than 200 international Pacific dispute settlement mechanism after this aggression. What does this mean? It means that there is a country who's victim, but that particular country is still trying to trust the existence of international law, and finally these international organizations and international law will come to its rescue and will preserve the world order as it was always. So howsoever crook Russia is trying to be, see, Russia may be crook in international law, but Russia की अपनी मजबूरियां हैं. You need to understand that as well. ठीक है? You must understand, if US comes, I mean NATO comes at the border of Russia, nobody is going to stop a war between, a potential war between EU, US and Russia. It's a dangerous thing. मैं तो ये बोलूंगा कि ये यूक्रेन का जो ट्रबल हुआ है, it will actually preserve, I mean it has a potential to avert a potential World War III. ठीक है? Of course, I'm very sad for Ukraine, whatever is happening in Ukraine. That's what Professor John Mearsheimer has prescribed also, that Ukraine should go on to become a neutral and non-aligned treaty, non-aligned country between Russia and EU. There should be a revival of the concept of neutrality. 1815 concept of Europe में दो neutrality establish हुई थी, इसने 50 साल तक वर्ल्ड में पीस मेंटेन की थी. Dutch neutrality and Belgian neutrality. 50 नहीं, 1914 में जर्मनी ने बेल्जियन न्यूट्रलिटी वायलेट की थी, तब जाके वर्ल्ड वॉर 1 हुआ था. ठीक है? बेल्जियन न्यूट्रलिटी एंड डच न्यूट्रलिटी. सिमिलरली इट इज टाइम फॉर यूक्रेनियन न्यूट्रलिटी. दैट इज माय की टेक अवे on my understanding of world history, international politics and international law together. All right, I'm here for questions if you have any. Otherwise, thank you so much. You have been really nice audience. I'll now take pleasure of reading those chats of appreciations. Thank you so much.
Also, Sudhir sir had mentioned a few article links that we'll be putting it in the chat, so you all can read it after the session today.
I'm just scanning it for everyone.
Since there are no questions, yes, there are no questions. On behalf of SPIL, I would like to express my heartfelt gratitude to you, sir, and all the participants that have been very patient and been listening to.
You've gone mute, Prince.
Okay, so I'm so sorry, there was some disturbance. So thank you, sir. This was an extremely insightful session from different aspects that you have covered, from geopolitics to international relations, ethnicity and international law, most importantly. You also got into the intricacies of Minsk agreement, Normandy format, trilateral contract group, ICJ order, and so many other judgments for our better understanding. So we are very grateful for that too. Also, SPIL Mumbai has been very grateful for your constant support and contribution towards our committee, that you've been participating in a lot of events for us. So we are very thankful for that too. Apart from that, to all the participants, I would like to extend my gratitude and say that thank you so much for being with us and listening to this, for being a part of this webinar. Hence, I officially call it an end to this webinar. After Sir has shared his notes, I think we can leave the meeting. Thank you so much, guys.
Thank you so much, Princey. Thank you so much, SPIL, and thank you so much, all the participants. Thank you so much for all the appreciations.